Trials isn't just arguing. Trials is getting in evidence. There's a whole series of rules that are required to get your evidence in front of a judge. Hi, I'm Russell Knight. I'm an attorney. I'm a divorce attorney here in Chicago, Illinois, and I also have an office in Naples, Florida. And unlike a lot of divorce attorneys, I really like trials. I really like going in front of a judge and explaining what's what. Judges can only consider evidence and your arguments. You can't just have arguments. You have to bring in facts that the judge can weigh. So I want to explain in this video and some subsequent videos how to get evidence in. Now, let's talk about what trial is and why people are afraid of trials. They really should be afraid of trials. Most people think that getting your evidence in front of a judge is like what they're used to, like getting a homework assignment, bringing in that homework assignment to the teacher, and then having the teacher grade the assignment. If your grade is better than the other guy's grade, well, you get an A and they get a B. But that's not how it works at all. A trial is like a teacher requiring you to do a presentation, and all the other kids in the class can yell at you during the presentation. And if they yell enough, the teacher might not decide to actually accept all the documents or whatever things you prepared for your presentation. So it's kind of terrifying. You must use the rules of evidence to get past those issues. You must be able to be prepared for the other side to yell at you in the middle of you talking and say, no, I'm not bringing the rules of evidence. This is how it works. I'm bringing in things the way they are supposed to be brought in. So let's talk about what are the big objections, the granddaddy of them all, that your opposing side will use and that you will probably use as well. And if you know how to get around it, you'll also know how to get your evidence in. And that big objection is the objection authentication, also known as foundation. I'll get into the difference in a minute. The Illinois Rules of Evidence 901A says that the requirement of authentication or identification as a condition precedent, that means you can't bring in or make a piece of evidence admissible unless it has been authenticated. So as a recap, evidence is two things when you're in a trial. It's the testimony of a witness. Testimony is evidence. If you say something, that's evidence. And exhibits. Exhibits are a document or a picture or something that helps the judge decide. And so people really lean on exhibits because they're used to that homework analogy, like I told you. They don't just like to tell their story. To bring in exhibits, they have to be authenticated. Authentication is so important because it lets the judge know that you know something. It's not enough to just say it. You have to explain how you know it to be true. Or in the case of exhibit, how you know that the exhibit is factual and actual and is a real thing. If we didn't have authentication, all of this evidence could just be a bunch of BS that you're making up on the spot. Or it could be difficult to follow sui generis statements that you think are self-evident, but the judge might be like, what? Like, where did that come from? That's authentication by saying that this is how you know something is true. He gets around that awkward way of communicating where you have the other person presume you know it's true. And you're really kind of blowing you off because you sound like a blowhard. So a good example of an unauthenticated statement is anything that sounds like it could be a conspiracy theory, at least in your mind or someone else's. So if you said, well, the moon landings are fake, you'd be like, well, how do you know that? Or if you said, well, my wife is addicted to shoplifting. Well, how do you know that? Like, it's kind of suspicious that you wouldn't say the reasons why you have this strongly held belief in something that probably needs more explanation. It's not authenticated information. That's why. So someone should be able to say objection, authentication, and judge should stop you in your tracks. So in sum, authentication is saying everything. You have to say in advance of the fundamental thing you're saying, judge, this is how I know it's true. For example, for a photo, I took this photo on June 2nd of 2012 in the Daily Center, and it shows my friend here walking in. And I like to submit the evidence now. So you authenticate it. You show, like, this is how I know what this photo is. I was there. I took the photo. That's it. Or likewise, if you made a statement saying, I heard his voice say, like, I'm going to get you. You say, well, how do you know his voice? Well, I've heard his voice hundreds of times before. We've known each other for years. I would always recognize his voice. The voice was loud. The voice was not muffled. So I was definitely sure it was his. That's authenticating what you say. When you authenticate things, it makes you more believable. How do I know this is true? And the tough thing is usually you have to say it before. Otherwise, they'll object. And then you'll authenticate it afterwards. It's easier to say, I know that the following is true because of X, and then you say the following. So if you can get into that staccato, that way of talking, you'll probably do a better job. There's no really specific way to authenticate all the different kinds of evidence. The Illinois rules of evidence give us a bunch of great examples, and I'm going to go through them, okay? They say, by way of illustration only, and not by way of limitation, the following are examples of authentication or identification conforming with the requirements of this rule. Number one, testimony of a witness with knowledge. Testimony that a matter is what is claimed to be. Non-expert opinion of handwriting. This is a great example. Non-expert opinion as to the genuineness of handwriting based on familiarity, not acquired for the purposes of litigation. How do you know his signature looks that way? Well, I saw him write his checks for 20 years. I know what his signature looks like. That's how. Comparison by trier or expert witness. Comparison by the trier of fact or by expert witnesses with specimens which have been authenticated. That's where we get the distinction of exhibits and testimony. Exhibits still have to be authenticated as being real. Testimony has to be authenticated as being truthful or being known to be truthful. Distinctive characteristics, the appearance, you can talk about how you know something looks like something. Voice identification, again, you recognize his voice. Telephone conversations, you have to say when the call happened, how you know you recognize the number, you recognize the voice. Public records and reports, evidence of writing authorized by law to be recorded and filed. Well, most things that are recorded and filed, they're automatically authenticated because we just presume that the government knows what they're doing. Or if it said, June 2nd on the newspaper, we presume that that's the right newspaper. That's what the headline said. Ancient documents as well. If you have an old book, we can just sort of presume we're not going to dig up Abraham Lincoln and have him tell us that he wrote the Gettysburg Address. We all know the Gettysburg Address. It's self-authenticating. A processor system, somebody can testify as to how a processor system works. You can just take that as sort of self-authenticating. For example, I printed off a PDF. You don't have to explain what a PDF is. We all kind of know what a PDF is. Then finally, it lists out methods provided for statutes or rule, where there'll be a method to authenticate. Some of these types of evidence, which we'll get into later, have specific methods to authenticate it. So again, if you're objecting based on authentication, just imagine that you're saying, if you're the objector, that is, imagine that you're saying, how do we know that he's not just making this up? And so when you say objection authentication, you're really saying, Judge, how do we know he's not just making this up? And you can really get pretty far on that. The judge will probably then ask for a couple questions, tell me a little bit more about this, so that the judge can verify that this person is not making it up. And the judge may say, I'm not hearing enough. Well, what happens if a judge does that and you're trying to get your evidence in? You can just ask the judge, well, what would it take, Judge, to get this evidence in? What authentication are you looking for? As you remember, the Illinois rules of evidence say that by way of illustration, when it gives examples of authentication, you can ask the judge for an illustration too. The reason they're probably keeping the evidence out is they know the exact type of authentication they want to hear. There's no reason that a judge can't tell you that. The other rule about authentication, or the other word for it, is foundation. The two words are very interchangeable. Foundation is a little more specific. Certain items require foundation, like preliminary evidence that has to come in before you can get the item in. A good example, again, is like a photograph. Testimony as to who took it, when it was taken, where you were when you took it, before it gets in. That's foundation. Authentication is more of saying, how do we know this is true? It's a little more fuzzy. Authentication really works for testimony. Foundation works for exhibits. But in practicality, it doesn't really matter. Someone saying objection foundation and objection authentication are effectively the same thing. You need to say more about how you got to the point where you're trying to submit this as being true exhibits or true words coming from your mouth. So authentication and foundation objections are the only first hurdle that getting your evidence in. There's many, many more objections that the opposing side can ask you, like hearsay, relevance, and we're going to get through all of those in the videos that are coming up. So until then, please let me know if this is helpful at all. Like and subscribe. I'll have my article presenting evidence in the comments so that you can go ahead and read that, cut and paste, and prepare your own presentation and be ready for those objections. The other side does not need to let you know what they plan on objecting to, because the other side doesn't know what you're going to say. Both of you have to be on your toes. And if you're prepared, you shouldn't have any problems. The judge wants to hear as much as they can, but the judge also has to follow the rules of evidence. If you have all the rules of evidence at the tips of your fingers, the judge will probably assume that you have a pretty good grasp of the facts and of how the facts affect your arguments and how your arguments are in fact persuasive so that you or your client can get the result you want. Thank you very much.